Greetings and good morning, everyone. It is a real pleasure for me to be speaking with you today on the very topical issue of institutional and legal operating environment in our region, with a focus on legislative and regulatory actions which are necessary to support economic recovery in our region through expanded cross-border trading. This year, like last, have been very difficult for our region, as we all have experienced it. The COVID-19 pandemic has taught all of us a lesson on resilience. Resilience is defined as the capacity to recover quickly from difficulties. So when the pandemic hit our various countries, families, schools, government agencies, all of us were put to the test of resilience. How quickly could we rebound from the unexpected difficulties we were going through? And those organizations that were most resilient were able to continue to operate. And schools that were resilient did continue to teach throughout the pandemic. Banks that were resilient did continue to lend and to close transactions to support their customers throughout the pandemic, despite having a large complement of their staff not being able to access their facilities. Those resilient schools were able to function with their students at home and teachers also at home, unable to access their facilities. Now, what runs through all these organizations that allow them to function is technology. These who were most resilient, these organizations, either may have given already to their employees mobile devices, portable computers, telephones. So by the time the pandemic arrived, they were prepared to react. So their resilience was a product of preparedness. Technology was therefore the common thread, as I said, of these resilient organizations. So during this talk, I'm going to share with you, for the time that we have together, a number of suggestions on how our government, our region, can improve its resilience to be able to face the next challenge, and also to quickly turbocharge the recovery from the pandemic, from the economic difficulties that we went through because of the pandemic. Regulators have a role to play. So during this session, I'm going to propose essentially a number of legislative items that I believe our government, our legislators can take up, can quickly implement with minimum implementation cost, and be able to transform how we do business in this region, and therefore bring a lot of resilience in our economies. So just like our families and schools and companies were challenged, our economies at large felt the challenge as well. The World Bank did report this year that in 2020, the sub-Saharan Africa economies contracted by 2%. Now, that may seem small, but on a per capita basis, the World Bank continued, they noted that the contraction was of 5%. And that sent sub-Saharan Africa, for the first time in 25 years, into a recession. Now, considering our low base, given the size of our economy compared to the world economies, that's a major, major deal for us because we need a lot of growth to be able to make a dent in poverty in Africa. So going through a recession is really against the trend that we should be experiencing if we want to realize the promises of the SDGs on the continent. Now, the IMF has reported, last month, it reported that thankfully, the African economies, sub-Saharan Africa, has started to recover, and they project 3.7% for 2021 expansion and 3.5 in 2022. Now, that's good news. Now, the problem is that's not good enough because it's the lowest rate of recovery compared to other regions of the world. So we get a very, very difficult hit, and we are recovering the slowest compared to other regions. And this recovery is also unevenly distributed across Africa, across our region as well, as the IMF noted in its report from October. And one of the reasons for this uneven distribution of the recovery is, in the IMF words, regional disparities in resilience. So nations whose economies are most resilient are experiencing faster recovery compared to those that are not. So it's therefore very important for regulators and for legislators in our member states, in our countries, in this region, to focus on making certain regulatory and legal regime changes that will strengthen the resilience of our economies. One major area of that is to strengthen the ability of our region to trade more with itself and with the rest of the continent, and to do so with less reliance on paper, to do so with a lot more reliance on technology. Because we've realized that the world can come to a standstill where nobody is able to travel, nobody is able to go to their offices, and we have to keep the economies moving in that context. Bankers, as most people are in this conference, will appreciate this, how difficult it's been to try to close a transaction in the midst of a pandemic, especially a cross-border transaction, where you may have lawyers sitting in London, the lenders sitting in Nairobi or in Mauritius or in Kigali, and the borrowers sitting in Mozambique, and their parent company sitting in Dubai. And you can't travel. Documents cannot be flown from one end to another because the logistics have come to almost a standstill as well. And yet you have to close a transaction. You have to keep the flow of funds moving. We have to keep the flow of global trade moving. How do we realize that? How do we do that in the midst of a pandemic? We have to bring about changes in regulations, in rules that will allow our economies to function efficiently when the next pandemic arrives. And these changes will also allow our countries to turbocharge the recovery so that ours will not be the slowest, but can catch up or even surpass the recovery in other regions. So the first change, regulatory change that I would recommend to our legislators, to our regulators, is to pass rules that embrace the principle of equal treatment of electronic and paper-based information. If you think about it, we all believe that when you go to court, you have to go fetch for the original contract that was signed for you to be able to prove your case. So if you get sued, you start scrambling around to find the original contract because you believe the court can only accept the paper-based contract. Now, that need not be the case. That need not be the case. You should not have to go scrambling for the original contract that was signed 10, 15 years ago in order to prove your case in court. Countries should allow electronic information to be given the same treatment, equal treatment as paper-based information. In the world that's entering or is in some countries already in the cusp of the fourth industrial revolution, electronic information is the largest base of information. So it makes no sense for our economies to be based, driven, and judged primarily on paper-based information. And the United Nations Commission on International Trade Law, UNCITRA, since 1996, issued the model law on electronic commerce. The model law on electronic commerce essentially lays out the principles of non-discrimination in the use of electronic means and the principle of technology neutrality. Whether the information is created by email or by fax should not matter. As long as you can establish its veracity, it should be accepted, and functional equivalence among all those forms of information. So the model laws exist, and passing this principle will not significantly increase the cost of running the country, but will make the life easier for those who are doing things, running companies, running small businesses and large businesses alike, to be able to transact with the legal certainty that electronically created, electronically generated information is just as good as paper-based information. Now, we can all start to imagine what this can do to how we do our work for bankers, for lawyers, for all companies, logistic companies, and so forth. So that's one critical one. Again, it's a very easy rule change, but it's an overarching principle that our countries need to adopt. The principle that electronically generated, electronic information is equivalent, just as good as paper-based information. This would change how courtrooms operate. It would change how banks operate. This will change the rules and the standard of evidence. It would transform how we do business once this principle comes in to replace the notion that paper is superior to electronic information. Now, the second change that kind of dovetails on the first one is this set of rules that recognize electronic signatures. Now, we've all heard about DocuSign and other e-signature solutions such as DocuSign. Now, the problem is not all countries have adopted even the beginning of rules that would recognize DocuSign or e-signature as a valid mode of signing document. Now, the pandemic has shown to us that it can become literally impossible to sign documents by hand in a pandemic because you can't get out of your house, you can't travel, and it just becomes impossible to do. Now, if all our countries had adopted or do adopt the electronic signatures as being equivalent to handwritten signatures, we can sign documents with people who are in Rwanda and others in Kigali, Rwanda, others in Kinshasa, in Bujumbura. They can all close a deal without ever seeing each other and with the legal certainty that their signatures are valid just as if they were done by hand. Now, all those countries I mentioned, though, will have to have equivalent or similar rules in order for the signatories sitting in different countries to believe that all their signatures will be recognized and accepted as valid. So just one country having this rule is not enough. It may be good for the domestic market, not good enough for the cross-border market. We need all the participants in the trade space in our region to adopt these kind of rules, to make them efficient across the board, and to allow these rules to be embraced in international trading, in cross-border trading, because that's what we need to really help our recovery be resilient by relying a lot more on intra-Africa trade. Kenya, to its credit, during the pandemic last year, through the Business Law Amendment Act 2020, Kenya, which already has a fairly robust e-signature law, did expand its electronic signature law to include the capacity to sign even land transfer documents electronically. Already Kenya is moving its land registries to an electronic platform. So it made sense for them to use the crisis to expand e-signature. But the rules are yet to be passed for implementing this law, but at least the trend is good. And the responsiveness of the regulator is one to salute, that they saw a crisis, they passed a law to expand e-signature beyond signing NDAs and other vanilla contracts, but they went as far as allowing e-signature for signing even land transfer documents, which will be registered, the land registry. That's how far we need to go to bring this kind of efficiency in our economies, to make them resilient, to be able to withstand the next crisis, and also to allow a faster recovery because of all the savings that will come from these efficiencies. The third rule that our legislators should adopt, again, on e-signatures, as you may suspect, UNCITRA, the UN Commission on International Trade Law, does have a model law on electronic signatures since 2001. Very easy for countries to adopt that model law. It's the basis for most laws in many other countries, and easily adopted. There are enactment rules and regulations that countries can look through to make it easy to implement these rules and quickly deploy the rules in the country. So very, very easy to do because the templates are there, but the impact will be massive across the economies. The third set of rules that countries have to adopt are rules that would recognize electronic transferable records, ETR. Electronic transferable records are records that we who operate in the space of international trade recognize very well. Things like bills of exchange and bills of lading, promissory notes, and the likes. These are documents that evidence a claim for the performance of an obligation, like a bill of lading, and that allow the person who holds them to say that they do actually have a claim on the obligation that's stated in the document, and they have the right to transfer that claim to another person by handing them the document, basically. So bill of lading, as we know, are very, very crucial documents for global trade. They have to be flown from one country to another when merchandise, when goods are shipped from one country by sea or otherwise to another country. The pandemic showed us that this is difficult to do when there are no planes flying around or not enough of them. So it has taken a long time to conclude transactions of the supply chain disruption we are hearing about, are compounded partly because of this physical movement of documents. Imagine if all the countries of the world, all the countries of our region had adopted rules that recognize electronic transferable records, so that an electronic bill of exchange, an electronic promissory note, an electronic bill of lading is given the same recognition as a physical one. Suddenly, we can actually, at that point, implement smart contracts. Those contracts that can be signed through blockchain, for example, from end to end, because there's no intervention of physical documents. Nobody is expecting them at the customs point of entry. Therefore, you don't even have to ship them. But today, the use of blockchain, as you may hear from other speakers at this conference, is limited because at some point, the physical documents still have to travel. So we are not yet able to take advantage of this advanced technology, which bring traceability and verification of control and of reliability of all these documents, as long as some countries at some point still require physical record of these electronic transferable records. So again, the UN Commission on International Trade Law has passed a model law on electronic transferable records since 2017. So all our countries have to do is to adopt this model law, and all of them, most of them, have to do it to make it effective in actually changing how we conduct international trade, how we conduct transactions across borders. The efficiencies we'll gain from that will certainly, and in a very, very significant way, add up to the growth rate of our economy, the expansion of our economies. Because just imagine how much money will be saved from eliminating the transfer of paper documents across countries. And lastly, the fourth critical piece of legislation that I would recommend to legislators in all our member states, in all our region, to consider and join is the 1961 Apostille Convention. The Apostille Convention is a convention that was drafted by the Hague Conference on Private International Law for the sole purpose of abolishing the requirement for legalization of foreign public documents. Anyone who has ever tried to get a notarized document from one country to be admitted in another country as an official notarized document understand the challenges of legalizing documents for the purpose of using them across border. So in Kenya, for example, in order to legalize a document, that's a notarized document, you must produce that document after the notarization to the High Court to verify, and then to the Ministry of Foreign Affairs at the legal department, and then to the embassy of the country where the document is going. Only then can you ship this document to that other country. Let's say the country in question is Uganda next door, or Zambia, or Rwanda. But you have to go through all these steps in order for your 1-page or 100-page notarized document to be validated for its recognition in a neighboring country. Just imagine how many weeks. This process can take months. This process of legalizing document can take months. In a pandemic, it's taking months, as a matter of fact. Now, the Apostille Convention does eliminate this process, because as long as the country where the document originates and the country where the document is going are both parties to the Apostille Convention, all you have to do is go to one office, the Apostille office chosen by the country in question, where the document is originating. They give you a certificate of apostille. You attach to your original document, to your notarized document. That's it. One document, certificate attached to your notarized document, you're done. You go to the other country, it's recognized as a valid notarized contract, notarized instrument. Now, 120 countries in the world have ratified the Apostille Convention. In Africa, only 11 have done so. In East Africa, only Burundi has done so. Now, no wonder we waste so much time and money in shuffling documents around. We can't close transactions quick enough. We can't deal cross-border fast enough. If all our countries could ratify the Apostille Convention, we will save a lot of time and a lot of money. And these changes to regulations can be adopted very quickly because the model laws exist. They can be adopted even at the REX level, at the level of the regional economic communities, so that they can apply across the board. But these are critical changes that will make our economies very resilient. And our call is really for regulators, for legislators to do their part in adopting these changes to make our economies even more resilient and our growth even more robust. Thank you very much, and I appreciate the opportunity to have shared this with you. Thank you.